Okay, he may make a statement either under oath or not under oath at his choosing, allocution or otherwise.
He's allocuting.
This right here is the turning point. The defendant wants to speak directly to the judge. Anytime that happens in court, things can get unpredictable fast. Judges usually prefer attorneys to speak on behalf of their clients, so this move could go either way.
Okay, you may make a statement, Mr. Soto Escalera, at this time. Go ahead.
Thank you, sir. What I'm bringing to the courts to address is, I have a conflict of interest. Mr. Thomas Burns. So I was asking for your permission, if it's possible, if I can get him removed from my case because I don't trust him.
Mr. Soto Escalera, trying to think of how to say this in a way that's most understandable. I think there's an expression, we're at the 11th hour. This is probably even beyond that. We're probably at about 11:59 here. We're about to close all of the evidence in your case, which would be submitted to me with the jury's recommendation, whether you should receive the death penalty or life in prison.
When the judge says, we're at the 11th hour, maybe even 11:59, that's not just poetic talk, it means the trial is practically over. The defense is out of time, and any last-minute complaints about the attorney are almost impossible to act on. You can feel the tension tightening in the room.
Counsel has already done his job. They've already completed their work on the case. Really, at this point, all that's left for them to do is argue to me. So I don't believe there's really any purpose in that at this time. Even if I were to grant your request, there's nothing left for counsel to do at this time other than to make argument to me, which quite frankly could be persuasive, but given the judge's function, where we are, as I mentioned, 11:59 metaphorically, there's really not much purpose in that. So from counsel, since it does affect counsel, does counsel agree with my observation on that particular point? I'm going to inquire Mr. Soto Escalera whether he wants to speak about the decision I have to make and give me input in that regard, because he has the right to do that. But that's separate and apart from what's being said now. Does counsel for the defense agree with my observation as far as, if this is a request to discharge counsel, where
Absolutely, Judge, and that
the horse is out of the barn at 11:59 p.m., I suppose would be the metaphorical.
correct. And as I explained to my client, I am not qualified to be on the case by myself because I'm only second share qualified. So Mr. Burns has to remain on the case to the duration.
Right, and just for the record, we haven't heard the arguments yet, but there's been a substantial amount of mitigation put before me, both at the trial and additionally here today, that I have to consider and digest, and does not seem to me that there's any reason for me to discharge counsel at this time.
Let's pause here. The judge just confirmed he's not removing counsel. This means the defendant has to keep working with the same lawyer he doesn't trust while facing a possible death sentence. That's a chilling position to be in.
More importantly, before you brought that up, Mr. Soto Escalera, you do have the right to make a statement at this time, either under oath or otherwise, that I would consider in making my determination in this sentencing proceeding. You understand you have that right to do that?
Yes.
And I was assuming that you were going to do that. I'm not saying whether you should or not. That's between you and your counsel. But I want to make sure that by me dismissing your conflict of interest issue, you don't take that as me dismissing your ability to make such a statement. Do you wish to make such a statement, or do you wish to talk to your counsel about whether you wish to do that at this time?
The only reason why I brought it up, Your Honor, is because something has surfaced with a witness and it was recorded in audio. This is why I'm requesting that I would have him removed. But if I can't remove him, I would like you to see what I'm speaking about so you can understand what I'm trying to say, if you have the time, Your Honor.
With regard to that, that would be a decision in this very important context for your attorneys to make, whether to submit that issue to me as far as potential mitigation. And as I'm required to do, I would defer to their professional decision in that regard.
Enough. I think enough. Judge, I'm going to lay it all out on the record, okay? I think Mr. Soto Escalera is hurting his situation. He's proceeding in ignorance on the advice of ignorant people. What he is referring to is a Zoom recorded deposition, the first such deposition I ever did in my life, with witness Lucinda Cook. This was done, I think, on the Tuesday when there was a court holiday, when we were in the midst of trial or jury selection. I'm not sure exactly where we were yet.
Whoa, the defense attorney just snapped back, calling his own client an idiot. That's an explosive moment in any courtroom. But behind the outburst lies something real. Attorneys get frustrated when clients misunderstand behind-the-scenes chatter. Still calling your client names? That's a risky line to cross in front of a judge.
And before Ms. Cook joined, there was a recording with chit-chat between me and Mr. Richardson about witnesses in the case, about the state of the case, about why I was calling witnesses and not calling witnesses, and complaining about somebody who had Ms. Minton's credit card and was going over the limits, and chit-chatting as counsel do between themselves waiting for a witness. And I don't think people understand the context of how attorneys talk to each other. I think that the witnesses who overheard this, Ms. Lucinda Cook and whoever else she communicated with, think that because this is a capital murder case, me and Mr. Richardson should be like this with our hands around each other's throats every moment. And we were not that way. We were chatting as counsel do in a case. And in a capital case especially, do counsel and adversaries have to communicate frequently and exhaustively to get the thing from start to finish done. That's all that it was. There is nothing in there that was inimical to Mr. Jose Soto Escalera's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case or in the trial or in the penalty phase that was contrary to his interest. It's nonsense and bullcrap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot. On this issue, at least.
In that regard, for Mr. Soto Escalera's benefit, the people who are here observing this proceeding,
The judge is doing damage control now, reminding everyone that even if the defendant feels betrayed, there are appeal processes for ineffective counsel claims. That's basically a way to argue, later, that your lawyer failed you. The judge is keeping the focus on the law, not the drama.
regardless of the court's sentencing decision, whether I impose a life sentence or a death sentence, there are appeals that take place directly, and then indirect appeals which relate to assistance of counsel, whether the defendant received proper assistance of counsel. That's for a different day. I could see this coming up perhaps in that scenario on the merits to be figured out at that time as appropriate, which goes back to what I said before. The evidence is in, mitigation has been placed before me, so we're at that stage where I'm to consider that. Put differently, if Mr. Soto Escalera feels that Mr. Burns did not properly litigate his case for whatever reason, there will be a proceeding in that regard. But to be fair to Mr. Burns' respected counsel before the court, usually what has to be shown, or what would have to be shown, is something of substance, not just some.
And here, the judge brings it full circle, calmly steering back to the real question. Does the defendant want to make a final statement? You can sense the exhaustion in the courtroom. After all the emotion, the system still demands order.
Idle remark we see from criminal defendants all the time, like, my attorney is working for the state, because look, they're smiling at each other and they're acting as professionals and not constantly cursing and berating each other and putting each other down. That's not the expectation of the court. In fact, we foster the opposite as professionals, that they get along, because once this case is over, they'll be on to a next case, and so will I. And so as professionals, they have to work with each other. But more importantly, as I mentioned at the outset, that is for another day. I'm directly focused on the extremely consequential and important decision I have to make, which goes back to whether Mr. Soto Escalera wants to make a statement regarding himself, the case, for me to consider. He does not have to, and it's not going to affect him negatively if he doesn't, but he has that right to do that. So there again, we broached a different subject. I don't want him to think that I'm not going to listen to that, should he wish to listen to make that statement. On the other hand, I'm not sure he has an intent to do that anyway. He just wanted to broach this subject.
Right, Judge, I think he
Okay.
said his piece and he has nothing
Okay.
to say at this
All
time.
right. So It's not the first time I've had to tell a defendant or someone else, that's for another day. There is a right to have a motion for post-conviction relief with regard to your Sixth Amendment right to counsel. That's for another day, really, regardless of my decision here. So other than that, that concludes the Spencer hearing evidence from the defense. Any evidence from the state before argument?